Okay, this hearing is in the matter of case number CFI 009-2023 before Justice Sir Jeremy Cooke.
Can you?
Yes, Ms. Martin, can you hear us?
Are you both able to hear?
I can't hear the court.
Yes, I am, my lord.
Ms.
I
Martin?
think Ms. Martin cannot hear us.
Could I ask, can the court hear me?
Yes, you're coming through loud and clear now.
Wonderful. Okay. I couldn't hear the court and I wasn't sure you could hear me before. My appreciation for the patience.
Right, let's go back to the form of words, please.
Yes, thank you. Okay, this hearing is in the matter of case number CFI 009-2023 before Justice Sir Jeremy Cooke. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimants are represented by HFW Middle East LLP. Lead counsel is Mr. Sharif Shivji KC. The defendants are represented by Jones Day. Lead counsel is Ms. Heather Martin.
Yes, Ms. Martin.
Thank you, Your Honor. I'll attempt to keep this very brief. On our view, the disagreement between the parties is really about process. This is not about Ms. Eason or Mr. Stubing, but about the process we follow to get to the appointment. And whether the appointee is Ms. Eason, Mr. Stubing, or someone else of the court's choosing. We believe the court's 30 April order is clear and unambiguous, and that we are simply following the process it set forth. It is also reflective of what the court said at the hearing when it said, in a quote that we believe is taken out of context by the claimants in its skeleton, that this is all I can do at this point, which is to await the agreement or not of the parties, and as it said, order the appointment if no agreement could be reached. So that said, we also think it's a bit silly for the parties to be telling Your Honor what it is that you meant when you drafted paragraph 14 of the order, given that the court's language differed somewhat from the language proposed by either party. Our skeleton sets forth the view of how the process described in the order should play out, in our view, and including the characteristics of the new office holder should occupy, namely residency in the DIFC. I suppose what we don't say is what those characteristics should not be, namely either practicing at a Big Four, because as we discussed with Pinsent Masons, we both think that would probably end up being too expensive. We also think there's a high likelihood of conflicts, nor do we think that the appointee should come from an overly small shop, given the resourcing concerns that Mr. Hayter has already described his medium-sized family-owned business incurring. So the only other things we wanted to say to the court today are in response to the claimant's skeleton. Throughout their skeleton, the claimants describe the fourth defendant's application as one to remove Ms. Eason, and we of course say that we're not seeking her removal as she was never validly appointed, and that pursuant to this court's order, paragraph 14, Mr. Hayter remains the office holder. But taking a couple of what we consider to be the more inflammatory points in their skeleton one at a time, starting with paragraph 2. which can be found at the hearing bundle at page 1022, if the court would like to turn to it. They state, since the estate is insolvent and has no independent means of funding the liquidator, it is unclear how Mr. Stubing's fees would be financed. The obvious inference is that he has had assurances from BJSS in this regard. This is false. We had no prior contact with Mr. Stubing prior to us diligencing him for potential appointment. I found him on the list of DIFC registered practitioners. I sent him a cold email. I asked him to clear conflicts. I identified the fact that he would be inheriting a position as a party in a litigation. I made it explicit that he would be adverse to our clients, and did some minimal internal diligence to see if any of our insolvency practitioners in London had had any contact with them, which they had not. We had one discussion with him, specifically Mr. Devenish did, in which he was very careful to not cross any boundaries that would even remotely jeopardize Mr. Stubing's independence. And it was, moreover, the same conversation we had with other candidates we vetted, which were 4 in total. So just to be extra clear, Mr. Stubing is not allied with BJSS, which is a phrase that the claimants take from Fielding to say that it would be inappropriate for him to be appointed. That BJSS simply nominated him in the same way that they would nominate an arbitrator as a party to arbitration. That arbitrator was not allied with his or her nominating party. Separately, in paragraph 2, the claimants state that BJSS has offered no reason why is it expending such significant resources in favor of appointing its own choice of liquidator. So this is also false. Again, we are simply following the process set forth by the court in its inherent jurisdiction over the appointment. Our costs in relation to this application were half of what the claimants were. And on these figures, one should be asking why the claimants are expending such significant resources, whilst the real parties in interest, the Al-Kharafis, choose not to participate in this process. A third thing that they state in that same paragraph is the obvious inference is that it perceives a significant tactical benefit. I guess it being BJSS perceives a significant tactical benefit in the litigation if its choice of liquidator is appointed. This is similarly false. We have no idea if Mr. Stubing would pursue the claims against our clients more, less, or equally vigorously as Mr. Hayter. Not only would it have been highly inappropriate for us to have asked for any such assurances, but Mr. Stubing, in his own professional judgment and obligations, could never have given such assurances, given that he doesn't know anything about the case, other than the fact that we explicitly brought it to his attention when we asked him to clear conflicts. In fact, even when Mr. Stubing was raised with the Al-Kharafi solicitors, Pinsent Masons, they stated they had no reservations about him, and they themselves had considered putting him forward. So this assertion is further false for the reasons set forth in our skeleton that we would be happy with any independent, duly qualified liquidator resident in the DIFC. We did ask other candidates to clear conflicts and can put forward one additional name if it would satisfy the court. But it should be noted that other candidates expressed an inability to fulfill the role given the complexity of the situation as between the parties. Now, finally, by pointing the finger at us with these allegations, as my mother frequently said, if you point the finger at somebody else, you always have 3 pointing back at you. And so what it seems to be suggested in the claimant's papers is that the Al-Kharafi sought assurances, or perhaps that Mr. Hayter sought assurances from Ms. Eason that she would carry forward the litigation. One at least has to ask the question, given that these ideas came from their imagination, which is, in our view, still wild. And in paragraph 9, they echo this baseless and allegation where they explicitly call us disingenuous and tacitly suggest that Mr. Stubing is unethical. We would ask the court to rebuke these assertions as forcefully as it has when defendants expressed views about the involvement of the Al-Kharafi's counsel in this matter. Separately, a couple of other paragraphs that we wanted to address. Paragraph 4. And elsewhere, the claimant suggests that we did not sufficiently object to the process they ran. Now, one has to wonder on how many occasions and in what form, in claimant's view, the defendants must object in order for their objections to be valid, we would submit that we stated our objections clearly, concisely, and timely, and that the claimant's demands that we engage in their endless letter writing campaign need not be countenanced by this court. In paragraph 8, they say that BJSS did not object to the adjudication of voting rights at the creditors meeting. Now, I was excluded from the creditors meeting, but I understand that Mr. Hayter ran through the adjudication in too great of haste and too little detail to even be understood. That Mr. Devenish asked for clarification and Mr. Hayter declined, stating that the adjudication would be clarified in his report to the court. BJSS therefore objected timely, following its only real opportunity to review the adjudication. Now, claimants heavily focus on the ordering of certain correspondence, focusing intensely on one clarifying email to the registry in which we asked that its most recent prior correspondence be placed before Your Honor. We would suggest that this line of argument is a distraction. Our correspondence to the court has been timely and forthcoming. Their complaints about the timing of this application are also unfounded, as no prejudice has accrued to the estate in circumstances where the court has not appointed the replacement liquidator, having explicitly created the expectation that it would do so on 10 June. In paragraph 19, they say, it is plain that BJSS was hoping to use the application to crowd out the disclosure issues. But again, no, this is false. What is plain is that even when the defendants attempt to follow the process clearly articulated by the court, the claimants will complain of ulterior motives and improper process. The claimant's over-egging of the custard is clear in this particular instance. In paragraphs 22 and 32 and 33, the claimants state that we have changed the basis of our argument. This is also wrong. In paragraph 22 references our 30 April letter requesting that the court appoint a new replacement liquidator from the nominees, and concludes that the use of the word new is a recognition of Ms. Easen's appointment, but this quote is presented out of context. In, I believe, the very same paragraph, we explicitly noted that Ms. Easen was not appointed in the preceding paragraph, the preceding paragraph, and the request for a new replacement liquidator was referring to the replacement of Mr. Hayter, not a replacement of Ms. Easen. Paragraphs 32 and 33 similarly misconstrue our position. The claimants point to our comments at the creditors meeting that when a liquidator has been removed, the appropriate procedure is for the creditors to agree amongst themselves, or in the absence of agreement, that the court should make the appointment. The claimants attempt to differentiate our witness statement, which says that the process after removing a liquidator is discretionary for the court. These positions are hand in glove. After removing a liquidator, the process is discretionary for the court, and here, using the court's discretion, it laid out a clear process. In the section of their skeleton in the paragraphs numbering in the 30s, describing their view of the operation of Regulation 6.13, they omit to grapple with the fact that this section refers to a clear majority, which, while not defined in the regulations, must mean something other than a simple majority. Otherwise, the use of the word clear in clear majority is negatory. Additionally, otherwise, why did Mr. Hayter feel the need to adjudicate BJSS's voting rights at a clear discount to his proof of debt? And why did the court specifically request that we go away and seek agreement with the Al-Kharafis if the Al-Kharafis' vote was always going to be the preordained dispositive vote?
Well, there's an obvious reason for that, Ms. Martin. One simply wants to avoid disputes.
Yeah, I can appreciate that. We wish to avoid a dispute as well, but unfortunately, we're here. So in paragraph 54, which the claimants argue should govern the court's use of its discretion, it's interesting in several regards. First, it is the first time where the claimants acknowledge that the court has such discretion. And second, it makes reference to a nominating party having their way when they are contributing to the assets of the estate. Now, this brings up a really interesting point. The Al-Kharafis are not here to press their case. So this puts us in an odd procedural posture where it is the nominee with a self-interest in the appointment arguing in favor of her own entrenchment. There's an argument to be had. We believe that she does not even have the standing to do so, but in any event, the court should like the optics of this scenario no better than the optics of appointing the nominee of a defendant in a litigation. If the Al-Kharafis were really so wedded to Ms. Easen, one would expect them to have shown up to press their case, but instead it's Ms. Easen here pursuing a position that is plainly self-interested. So finally, the claimant's note in paragraph 56 that we don't criticize Ms. Eason. And we would say that the only thing we really have to say about her personally or professionally is that we have no real information about her because she made so little effort to make time to speak with us. This, of course, did nothing to cement our confidence that she would come at the matter as a true neutral and representative of the court. But that, of course, is not something we can conclude upon solely on the basis of an absence of information. In terms of Ms. Eason's location, it is not only our concern, it was a concern expressed by Pinsent Masons in our discussion with them. Now, they obviously got over it for some reason, but they're not here to tell the court why. And to put slightly more flesh on the bones of the fourth defendant's concerns, we would point out that if the documents or copies of documents are deemed available in the UK in a manner that falls outside of privileged channels, this potentially introduces a whole additional jurisdiction to regulated client information. The clients had not consented to their account information being in the UK, and such a scenario is outside of what the fourth defendant's own regulator would have contemplated for these clients. The court determined that removal was warranted for Mr. Hayter and laid out a process for appointing his replacement. That process sought agreement between the parties to avoid repeating some of the disputes of the past. And in the absence of such agreement, it was deemed best for the court to determine the replacement liquidator to start off on a clean slate. We submit that a DIFC resident liquidator is the natural choice for a DFSA regulated financial services business. We submit that the court should, pursuant to the process that it ordered, appoint such a candidate in which it has confidence in their independence and capabilities. Those are our submissions.
So just to answer these questions, could you please, Ms. Martin?
Sure.
The first question is, what do you say about paragraph 33, subparagraph 5 of the Fielding against Seary decision? I'll give you the series of questions so that
Sure.
At the same time, if you want to make a note. The second question is, what process do you actually say should have been followed? And I think that'll do for the moment. Those two questions for the moment. Thank you very much.
Yeah, so Fielding, as I understand it, was a slightly different factual scenario where originally there was one defendant to a litigation who tried to get a creditor vote to get a liquidator removed, and upon, I think, the failure of those efforts, it went immediately to the court. And it tried to not only have the liquidator removed, but have the liquidator removed and have its own selection appointed in one go, which is obviously not what we did. We weren't trying to substitute.
No, but it's not the facts. It's the principles that have been set out that have been approved in subsequent cases, including in particular by Mr. Justice Marcus Smith.
Yeah, well, we certainly support Fielding in that it makes it clear that the court has the discretion to make this appointment. Now, we would suggest that the court should tread very carefully at the very least, because all of these decisions are going to be quite precedent-setting in the jurisdiction about the idea that someone contributing assets to the estate should really have the say in who the liquidator is or should be, and that their opinion should be granted additional weight. We, as I think we've been consistent in all of our arguments, that independence should be paramount here, and that it should not simply be one creditor's choice, so that they can, particularly where there are two all nearly equally weighted creditors who are the significant creditors, that one of them should be able to control the conduct of the liquidation or even of a litigation. We would ask the court to reject the suggestion that the Al-Kharafi should have the ultimate influence here. We don't know anything about the independence of Ms. Eason. Again, they haven't put in any information about it. The court knows everything that we know about Mr. Stubing. But all we know about Ms. Eason is that she came as a recommendation, we believe, from Mr. Shivji or his chambers, but that was Pinsent Masons. They said that they received it through HFW, but that they believed it came from counsel in London. That is what we know. And we don't believe that those are good optics for this court to adopt or to countenance in any such future decisions. In terms of the process that should be followed, I thought that the court got it right when it said, please go away and try to agree. And if the major creditors can't agree, then the court will assert its jurisdiction over the matter, which in our understanding, the court already has, because this is sort of an inherent tail of a removal pursuant to Article 103. So where...
But if, for example, the parties had agreed, when I say the parties, I mean the Al-Kharafis and your clients as the major creditors, what would have happened then?
I think we would have submitted a consent order to the court.
But I couldn't do anything about that because the other creditors wouldn't have had the opportunity to have a say. I can't ignore the other creditors, even if they're very small by comparison. There had to be a process, didn't there, of going through a creditors' meeting. It seemed to me that was always inevitable.
It was not what we read, what was contemplated in the court's order, and I understand the court's concern in that regard. And as you'll see, our client voted in favor of the creditors' meeting, that the cost going into the liquidation. We didn't object to the creditors' meeting being called because the liquidator always has the authority to call a creditors' meeting. We did not view this as the process contemplated by the court. But what we heard from the court is the court asked us to go away and agree. If the court had said go away and follow the process,
there's no question the court asked you to go away and agree. The question is what the consequences would be of either agreement or disagreement. But I was hoping, and perhaps I should have given up hoping for any agreement in this matter. I was hoping that there would be a agreement on a liquidator whose independence, therefore, could not in any way be the subject of challenge or argument. Well, one lives in hope, I suppose. There we are. Is there anything else you want to say?
Not other than perhaps in rebuttal.
All right. You don't want to take me through the transcript of the hearing on the 19th of April?
I don't want to take you through the transcript now. I'm sure the court is well familiar with.
Well, I haven't read it in detail, so if there's anything in specific you want to take me to.
Well, we do say that where they argue that the court essentially constrained itself in what it had the ability to do and constrained it and fettered its own power. And I
don't think I ever fettered my own power.
Yeah, but what I would just like to read the quote that they pull out in context, where the court said, "I think that that is what the position is. I think I have indicated that what I hope will happen. I have indicated that I will determine any applications which are made on 10 June in relation to the new liquidator and his identity. And I am certainly going to order that insofar it is a variation on what I've already ordered, the current liquidator is removed only when the new liquidator is appointed." I think that's all I can do at this stage, is it not? And Mr. Shivji agreed. Exactly. That is in my submission all that the court is being asked to do. As the court recognizes here, we don't subscribe to the view that the court agreed to any limitation on its own power in regard to this appointment. We believe that it is a discretionary matter for the court, and then the court should exercise its discretion accordingly.
All right. Okay. Mr. Shivji, what do you want to say?
I'll keep it brief, my lord. I appear in this matter on behalf of the estate. I'm instructed by Miss Eason because the view on our side is that she was properly appointed as liquidator. But I'm here to argue the position for the estate, not for any personal interest of any individuals concerned.
Yes.
There are 4 points that I wanted to make. One is that
before you begin,
of course,
before you go any further, perhaps you're about to deal with it in one of your points, so I may have interrupted prematurely. But for the sake of the record, would you like to say something about the suitability of Ms. Eason?
Yeah, in fact, that was my first point.
Very good.
Because that, I mean, really cutting to the my learned friend said in her submissions that they wish to avoid a dispute, but one wonders why we're here, because actually no objections had properly been raised to Miss Eason. There is no dispute that she is fully independent. In fact, the first mention of the word independence in relation to Ms. Eason came up in my learned friend's submissions, but there is no suggestion in the evidence or the application that she's not independent. There is no suggestion that she is not well qualified for the role. There is no suggestion she doesn't have the right expertise, and there is no suggestion she will not carry out the responsibilities of office diligently. There was also another new point in my learned friend's submissions when she said that the recommendation from Miss Eason came from me in my chambers. That has never been mentioned before. Obviously, I hesitate to say something that touches on evidence orally, but I think it is important I make it very clear that that is not the case. The recommendation did not come from me, nor Mr. Sampson. I've never acted for Miss Eason before. I've never acted for her firm before. So I don't know where that came from, but if that had been raised in evidence, we could have dealt with it properly. Now, the only objection, sorry, the one other point that my learned friend raised about Miss Eason, which is that she said she made so little effort to get in contact with them, and that's not fair at all. And actually, your lordship can see that from the bundle at page 879. Where she was contacted by Miss Devonish at the bottom of the page and onto the following page, it's 880, who explained who he represented, said he understood that she'd been nominated as a potential liquidator, and asked for an opportunity to discuss the mandate with her the following day, and asked if she would be available for a short call after 11:30 a.m. And she came straight back the same day. I think it was probably, I think the timestamps of the email might have different jurisdictions, so the timing might be closer. I can't quite figure that out. But at 8:79, she responds on the same day saying, I'm at a conference tomorrow, but I can pop out for a short call. Do you want to set up a Teams call? Now, in fact, BJSS didn't follow that up until the afternoon of the following day, when they responded at 8:78 saying, thank you for getting back to us so quickly. We didn't want to bother you during your conference today. Might you be free for a quick chat tomorrow morning? And then she responded saying that she wasn't available the following day. So for my learned friend to say that Miss Eason made so little effort, we think is rather unfair. She made herself available on the day that they asked, and they chose not to take her up on it. And then they wanted a call the following day, and she wasn't available on that day. So we don't think any fair criticism can be made of her for that. And of course, in any event, it would have been perfectly possible for them to follow up with her at any point since then. That was in late April, and we're now a month later. So it really isn't fair to say that Miss Eason hasn't made herself available when necessary. She is already in post, and the work is well underway for the preparation of the CMC in this matter on the 10th of June. The only objection that's been raised to her being in office is that she's not in the DIFC. And it's said that that's a point about costs, although there is a new point in my learned friend's skeleton argument that there is a public interest, they say, in office holders being based in the DIFC. I'll just deal with those 2 points swiftly. On costs, this is a hopeless point. The applicants haven't even attempted to show that Miss Eason's rates are higher than someone like Mr. Stubbing of FTI. FTI is a much bigger firm than Miss Eason's firm. And our view is that as a member of a relatively small firm, Miss Eason will be much more cost effective as to compare to someone who works for a very large firm. There is no practical, sorry, my lord.
What's the connection between MHA and Baker Tilly? I mean, I see it's referred to as an independent member of Baker Tilly International. Does Baker Tilly sort of operate as a franchise?
I do. That's a good question, my lord. Someone will find the answer to that while I'm continuing my submissions, and if I may, I'll come back on that point. I mean, the only point we think is of significance there is that through the operation, Miss Eason has access to all the necessary resources in the jurisdiction. So yes, we say that the structure, that's the only relevance of the structure, but I'll see if we can give you a bit more information about the structure. So I was just making the point, there's no practical difficulty with her being based in London. The council team, as you know, are based in London. And although they've raised BGSS has raised many objections about us, they've never raised an objection about the fact that we're based in London. And of course, this case can be perfectly well conducted from London. BGSS has never been concerned about minimising the costs to the estate. And indeed, we think its litigation tactics to date have been trying to maximise the cost for the estate in order to discourage it from bringing this litigation. And of course, all the many applications we've had to deal with, they've all involved the liquidator incurring time costs in dealing with them on behalf of the estate. And the estate has not been compensated for any of those costs of the liquidator's time, despite the estate having a positive outcome on those applications. So it doesn't really lie in their mouth to say suddenly that they are very interested in minimising the costs for the estate. And of course, if they were interested in minimising the cost of the estate, this application would not have been brought in this way at, frankly, this late stage. Can I then turn to the public policy point that my learned friends raised in their skeleton argument? That's a new point, not foreshadowed in any of their evidence. It's also a bad point because the insolvency regulations provide the qualifying criteria for office holders before the DIFC court. And there is no requirement that office holders are based in the DIFC. And this is covered by Regulation 7.1 of the insolvency regulations. And that explains that any person who is a member of a recognised professional body is qualified to act as an insolvency practitioner under the insolvency law. So there is that is actually inconsistent with what my learned friends are arguing for, which is a requirement that the office holder is based in the DIFC.
As a matter of interest, how many such practitioners would there be in the DIFC? I've come across about 4, I think, so far, maybe.
So we've ran some numbers. There's a register of insolvency practitioners maintained by the DIFC Register of Companies. And we ran some numbers just overnight on that. We think 75% of the practitioners on the register are outside the DIFC. Nearly 30% are based in London. Some are based in Cayman. But notably, my learned friend's own expert witness on how to administer a DIFC liquidation, Mr. Fleming, is on the register as a DIFC liquidator and, of course, is based in London. And my lord, in other, I think my learned friend in her submissions said that this was important because it was a DFSA registered entity that's now in liquidation. But my recollection is that the ES Banca, the Espirito Santo Bankers case, which was in liquidation in the DIFC, that the office holders there were also London based as well. And that was a big liquidation. It's quite a complex liquidation before this court many years ago. I think it's around 2014. So there's in my own professional experience, there's precedent for office holders holding offices of this court outside the jurisdiction. And we say, of course, all of that's consistent with the DIFC's international nature. Its advocates and indeed its judges don't have to be based in the DIFC in order to practice before the court. So we say it would be quite wrong for the court to insert a requirement or even to indicate that it would be preferable for practitioners to be in the DIFC, because to do so would in fact disenfranchise the majority of practitioners who are on the register and who the registrar of companies has chosen in the exercise of their discretion to admit those persons to the register. And by law, those really are all of the objections that my learned friends raises about Miss Eason. I mean, there's nothing of substance there. And so we say that before we even get into the mechanics of her appointment, and I do want to address you on that, but we say actually just cutting to the chase, my learned friends have not identified any reason why Miss Eason isn't an appropriate person to discharge this office. And this is simply a sporting tactic designed to impede the progress of the litigation, again, to set us back by a few months, to incur more costs, again, in the hope that we will be discouraged in the litigation. And can I just say a few words? My learned friend talked about Mr. Stubbing, and she covered some things orally that are not covered in evidence, including in relation to the discussions between BGSS and Mr. Stubbing. It's not ideal to hear those points for the first time orally, but just taking them at face value, her position is that Mr. Stubbing has no funding in place.
Well, Mr. Shifty, I'm not sure I'm very interested in all of this, because
Okay.
It seems to me the principle set out in the cases simply means that I would not be prepared to accept a nominee from a party against whom the estate was in liquidation, in litigation. I mean,
Well,
it seems to me, it's always seemed to me that that's a very strong principle. And had I had two candidates of equal weight being put forward in such a situation in any circumstances, I would simply say, well, it's quite plain what the answer is.
yes. Well,
Anyway,
I'm grateful for that, by the way. That was my that was my fourth point. So we swept away my first and my fourth. I briefly will address you just on the mechanism for appointing Miss Eason, because I mean, to us it does matter, because obviously the estate wants to do things properly, and we have given quite careful thought to following the proper process. And although we think it all ends up in the same result, that Miss Eason is the appropriate appointee, we do want to satisfy.
Can I again stop you there?
Okay.
Tell me if I've understood the position right. There is no express provision that says exactly what process ought to be followed in the event of the court removing a liquidator. But there is a process, of course, set out for what is the appointment of a liquidator. Is that essentially the position?
That's the way actually probably my learned friend would characterize it. I mean that is essentially right. But can I just explain the role of how we see the role of the court and the role of creditors' meetings? I mean, so essentially, much like a solvent company, there is a body of persons for an insolvent company that decide the ultimate direction of the company. And obviously for a solvent company, that would be the shareholders in general meeting. And for an insolvent company, that's the creditors in a creditors meeting. And in fact, the creditors have a slightly higher status within an insolvency, because of course the company is no longer a going concern and they are the sole beneficiaries of the outcome. And they have a number of powers, including the ability to requisition a meeting. But one of their most significant powers is to appoint and remove liquidators. And the reason for that is, I mean, much like the shareholders in a general meeting, ultimately the day-to-day management is left to the directors. But if the shareholders really don't like what the board is doing, the ultimate sanction is that they can remove the board. And is exactly the same principle for creditors. That is a general power that creditors have at all stages, that they can requisition a meeting and appoint and remove. And the court has a supervisory role over the liquidation. So although this is essentially a compulsory liquidation subject to the court's role is not to administer the liquidation for the liquidator. It is to supervise the liquidator's conduct of the administration. Yeah. Now, as part of the court's powers, it can remove a liquidator, and it can also appoint a liquidator, in particular, for example, where there's a vacancy. But the court's role is always in this supervisory function. So we would say that the ordinary machinery of the company ought to operate. And if you look at the authorities, the court tends to step in when the ordinary machinery usually fails. Now, I mean, I appreciate a bit of a generalization, and there are different circumstances in which the court intervenes. But we would say in a case like this, where the court has only been asked to remove the liquidator, the ordinary pattern would be that the creditors in general meeting would in the first instance decide the appointment question. I'm not saying, my own friend puts it very tendentiously in saying that we're somehow fettering the court. We're not. This is a court supervised liquidation. But I would say that the appropriate mechanism is exactly what we've done. And actually, it really is on my learned friends, because they chose in their removal application only to seek removal. They could have, in some of these authorities, you look at a party seeking the removal of a liquidator and they put forward the replacement. Here they chose not to do that. And if you look at their application notice, they only seek removal. And so they got what they wanted. They got their removal. They knew that we had been asked to requisition. Sorry, we knew that a creditor had requisitioned a meeting. They knew that the meeting had been called. They had no objection to the meeting, and we discussed the meeting at the hearing on the 19th. And my learned friend, in fact, was content with the meeting. She just wanted the date changed because of her own diary difficulties. So they were endorsing the calling of the meeting. They put forward their own candidate for appointment in the meeting, and thereby recognised that the meeting had the power to appoint, which of course it does under the law. And it was only when they didn't get the outcome that they wanted that they sought to reverse all of that process. And unfortunately, that isn't the way that it works. Now, my learned friend talked in her submissions about the threshold, and she said that the threshold under the law is higher than a simple majority. But that's a bad point, and indeed it would completely upturn the IFC law as compared to any other common law insolvency jurisdiction, if that were the case. But the law makes it very clear that, and this is paragraph 9.1 of Appendix 1 of the insolvency regulations, that what is required is a majority. And it's a majority by value by those creditors voting, and that's at page 1170 of your bundle.
Yeah.
And just to develop that point, that principle of majority rule, simple majority, is a key concept which runs through English company law as well as English insolvency law. And of course, your lordship will know in company law that the principle of majority rule is so embedded in the law that the courts have developed a limited exception to it under the concept of fraud on the minority. So you need to have fraud on the minority because of the risk of an oppressive decision by the majority. So we say principle of majority rule is standard. It's been the law for a long period of time, certainly since the Victorian development of company law. And it was a point that I drew to your lordship's attention at the hearing on the 19th. And my learned friend didn't want to take you through the transcript, but actually I would like to show you what I said to you about that point. And there is no part of this where we're trying to pin your lordship to the transcript, because your lordship has complete discretion in its supervisory jurisdiction. But what I'm trying to show is the points that I made, my learned friend took no issue with, and we did exactly what I set out that we would do. So if we could go to 816 of the bundle, please, my lord. So actually, if we pick this up at your lordship was talking about the possibility of trying to get agreement to a new liquidator, and we endorse what your lordship said, that obviously the most satisfactory outcome would be one where everyone was on the same page, and that's the point your lordship made in the middle of 816. Then I addressed you on that point, and I said, in order to minimise, we obviously take what your lordship says in the removal judgment, but in order to smooth the transition, we say it does make sense for this brief period for Mr. Hayder to remain in office until a new appointment is put forward. There is a process under the insolvency law for appointing liquidators, and that is the process that is being followed. So the meeting is being summoned, the creditors have an opportunity to put forward their own candidate, and then they vote. I'm not offering any observation on it at the moment. And then I went on, there was an issue.
Are you on page 816?
I was 816, and then I've gone to 817, my lord.
Right.
Not at all.
Yeah, sorry, I'm with you now.
Yes, so your lordship made the point about consensus in the middle of 816, and then I addressed your lordship on the mechanics of the meeting, and your lordship could just read my submissions at the bottom of 816,
yeah,
and then on to the middle of 817, where you say you couldn't. Then I think the audio dropped out for a moment.
Yeah. Yeah.
And then I go on to make the fielding point. If the defendant's hope is that they'll find their own candidate who they're proposing to fund who will then discontinue the litigation on the appointment. I mean, there are serious problems with that. And then I go on to say there will be a question at the meeting about the propriety of all of that, and I do not intend to express a view about that now. I've not considered it in detail, but it will be a matter for the person chairing the meeting to consider conflicts of interest and the propriety of the meeting. I then said that is a world in which there could be an almighty spat at the meeting, but I'm not trying to incentivize the defendant to do that. And they should not think that if they do that, they will somehow be able to come back before you and then be able to put a list of candidates before you and you will be able to choose one, because that is not how it works. This is ultimately a question of majority rule, and it is a matter for the creditors meeting in the first instance to decide on that in accordance with the process under the law. We will see how that meeting goes, but I just wanted to raise that with you. And then your lordship said, I'm not going to interfere with the ordinary processes unless an impasse arises where the court has to take action. As I say, one would hope the parties, the creditors, would reach agreement.
Yeah,
And
well, that's basically what I intended.
Yes, and we say that is entirely right, my lord, that your lordship, in the exercise of your supervisory jurisdiction, says let the creditors follow the process. If there is an impasse, then the court will have to be and we say that is entirely consistent with the authorities. But there is no impasse because the process was followed. The creditors, the insolvency rules provide for a majority by value to pass a resolution, and that is exactly what happened here. Now, my lord, I don't need to dwell on it, but we'll just pick up at 8:22 what my learned friend said about the suggestion that they might be trying to somehow shoehorn their own candidate. And my learned friend said it. Your lordship talked about trying to the parties trying to achieve an amicable result of the Carafes. Miss Martin then said it's certainly our intention, and I would notice Mr. Shively's comments. He has a wild imagination. I have to give him credit for it, that we intended to tee up a liquidator who were therefore going to fund a conflict out in that way. It never even crossed our mind. It's impressive, but it's entirely inaccurate. And then she later on actually admonished me for even raising the point, and asked me to stop making submissions of that nature. But my lord, regrettably, that's exactly where we've ended up. That there is no basis for vitiating the process that was followed. It is the standard one. There is no dispute that the meeting was properly called. There's no dispute that the meeting had the power to appoint a liquidator, and there's no dispute, no proper dispute, that the meeting was conducted properly in accordance with the rules. The point about the adjudication of BDSF's proof doesn't actually go anywhere, because even if their proof had been admitted for the full amount in value, the creditors still would have been, the Carafes still would have been the majority in terms of value voting on the resolution. But in any event, that the chairman, who at that point was Mr. Hayder, is obliged under the rules to adjudicate on the proof because it was a proof for an unliquidated debt. And actually, unless he puts a value on a minimum value on that proof, it has a de minimis value. So they in fact did better out of him adjudicating of the proof than if he had decided not to adjudicate it on it at all. But this, I mean, we could spend a lot of time examining the adjudication of proofs. It's completely irrelevant because whatever value is put on it, they remain the minority.
Well, it's an extremely difficult claim to put a value on because it's a contribution claim.
It is, and actually, there's quite a lot I could say about it. But
Yeah,
I'll just say one point, my lord, because I think it is an inaccuracy which we ought to be picked up. My learned friend's skeleton argument suggested that BGSS's liability in that litigation was all down to the conduct of Mr. Walia, and that's just wrong. They were found liable for a breach, for carrying out essentially a regulated business in the jurisdiction without a license. It's a completely different claim. But anyway, we'll if we ever need to, we'll come back to that later. So my lord, that is admittedly a whistle-stop tour of why we say Miss Eason was properly appointed by the creditors.
Yeah.
We didn't understand your lordship's order of the 30th, which is the day after the appointment, to essentially change the rules to impose a different regime. We also say the circumstances in which the communications that were sent to you on the 29th of April were very unfortunate from BGSS. We say it was particularly unfortunate that your lordship was sent a letter both before but also particularly after the creditors meeting that asked your lordship to put in place a regime for appointment of a liquidator in the absence of agreement, and your lordship's attention was not drawn to the fact there had been a meeting that morning. I mean, we think that a judicial eyebrow or two might be raised to that correspondence, and that correspondence came 20 minutes from the person who attended the meeting on BGSS's behalf, and it came 20 minutes after the end of the meeting. And we say that really ought to have been drawn to your lordship's attention, and your lordship may have considered whether to elaborate a bit more on the order in light of that.
Well, I rather suspect, though I don't remember, that I had approved a form of order the previous day in any event. I'm afraid that the norm is that when I approve orders, it takes a day or two for the registry to process them. So I suspect, you know, the sequence is very difficult to pinpoint. But yes. I'm pretty confident I wouldn't have seen any of the letters at the time that I approved a form of order.
Yes. Well,
was it after the weekend too? I can't remember.
It was after the weekend.
I thought it was, and I think my recollection, it is only a recollection, I could check, of course, but I think I probably gave my approval to a form of order on the Friday.
Yes.
And it's not a felicitously worded order. I accept that entirely.
I mean no criticism of your lordship at all, but we say that it should have been drawn to your lordship's attention that the meeting had, I mean, whether your lordship would have seen the letter or not, the correspondence was highly unsatisfactory, because it asked your lordship to put in place a mechanism where, in the absence of an agreement, without telling your lordship a salient fact, which is that there had been a meeting that morning which appointed an office holder. And whether that would have made a difference to your lordship is a matter for your lordship, but we say that the court ought to be given full facts. And really that, you know, the court does have an expectation on legal representatives to give the complete picture. So, my lord, we say that there's nothing in your lordship's order which, as I said, invalidates the outcome for the creditors' meeting. And in any event, the sequencing on that probably does matter, because the appointment happened on the 29th, yeah, and the order was made on the 30th. But anyway, that's a matter for your lordship. And then finally, my lord, I just wanted to address you briefly to say that although we've seen a number of surprising applications in these proceedings, this one is particularly unsatisfactory. It was designed to put Miss Eason as the liquidator in personal jeopardy, because it was said that she didn't have authority to conduct the terms of her office. But then BGSF then withheld or delayed making the application until we really stamped our foot. And we've seen this pattern of behaviour repeatedly from BGSS in this litigation, that it seeks to put the individuals, the professionals involved, under personal pressure to doubt whether or not they really want to discharge their function. And that is not a feature of litigation in any developed jurisdiction. Without wanting to be overly dramatic about it, my lord, attack on legal professionals for doing their job in the jurisdiction is an attack on the rule of law. And we've seen it so many times, and your lordship has admonished them in the past for doing that. And it's very unsatisfactory. It's happened again. But we say that Miss Eason is simply doing the task that's given to her. She is preparing hard now for the hearing on the 10th of June. There's plenty of work to be done on our side, and it really is important she's allowed to get on with that. My learned friend took issue with my submission that this application was intended to derail the CMC, but it's obvious that that's what they were trying to do. They put in a time estimate of 1 day for this application, and if you look at Devonish 15, it makes it clear that they were expecting the application to come on the 10th of June, and then they would use it to crowd out the CMC agenda, because of course it would be agenda item number 1. And one suspects that's the reason why they delayed making the application as well, because they knew that if it was issued too early, there would be a greater chance of it coming on early. And we say that is not an appropriate way to litigate. So, my lord, unless I can assist you any further, I mean, there is more technical detail to be given, but I'm not sure it will assist at this stage.
No, thank you very much. Ms. Martin?
Thank you, Your Honor. I believe that we made the application 2 days after they said we should have. I'm not sure how that's material, particularly in circumstances where the court explicitly said it would make the decision on the 10th of June. That's not an expectation that we set. That's an expectation that the court set. The correspondence that Mr. Shivji points to that says that we misled the court, again, I think that we wrote to the court within a day. It might have been 2 after the creditors meeting, apprising the court of the creditors meeting. We've been fully forthright. There was one clarification email to the registry just asking them to put a prior piece of correspondence before the court. We never attempted to mislead the court. The existence of this creditors meeting had been the subject of a significant amount of discussion at the prior hearing. It was not in any way concealed from or not made entirely transparent to the court. I do take issue. I find it interesting that Mr. Shivji says that perhaps I or Jones Day or maybe the defendants should refrain from making attacks on professionals, but I am feeling pretty personally attacked here by Mr. Shivji saying in the transcript that we intended to put forward a candidate who we had influenced, me saying that was absolutely not the case, and then him coming back with skeleton arguments that essentially say that is what we did, meaning I lied to the court in making that representation. That is the only reason I went into the steps today that we took with regard to Mr. Stubing. We didn't previously think they were relevant, but given these pretty robust attacks on our integrity and the integrity of the process, I felt it necessary to make sure that the court had all of the information in that regard. Now, turning to Ms. Eason, we stand by our characterization that she didn't make any real effort to talk to us, saying I'll pop out of a conference. I mean, conferences are loud, distracting places. They're not places to have real conversations about serious topics. And we didn't think it was appropriate to try and engage her on something this serious on a short call of her popping out of a conference when we didn't know how much time she would make for us. We consider it similarly unsatisfactory to say, oh, I'm going to be in Madeira. That's fantastic for her. I hope she had a wonderful vacation. But on the other hand, we all work when we're on vacation, when we're in roles that's important. And I would have thought that if the role were that important to her, she would have made the time to talk to us. Mr. Shivji is saying he doesn't know where the suggestion came from Vincent Mason's, that he made the suggestion for Ms. Eason. I mean, I don't know where it came from either, but that was Vincent Mason's. That is what they conveyed to us, and that can be found at paragraph 12 of our at page 838. And so
can my learned friend just turn that up, because I don't think it says, there's no allegation there that the suggestion came from me or my chambers, and I said it was a new point.
No, it's page 838, paragraph 12, and then that last sentence says, Vincent Masons did express reservations about Ms. Eason being located in London, but noted that she had been recommended by or through claimant's counsel.
Yeah, we didn't understand that to suggest that it was barristers rather than the solicitors, but anyway, there it is.
Obviously, being American, we use the term counsel slightly differently, but I would generally refer to barristers as counsel.
Yes, it's one of those problems that I frequently come across now, as to who thinks they're entitled to be called counsel. It used to be very straightforward, but what is the usage now?
For Americans or for English qualified practitioners?
Well, it's the problem is I come across an arbitration all the time, and someone says they're of counsel. I have no idea what it means. What do you think it means, Ms. Martin?
Well, in terms of my title of counsel at Jones Day, that denotes a particular relationship to Jones Day, where I am a senior lawyer, but I am compensated on a salary rather than based on partnership profits. In terms of my relationship to this court, the court generally emails us before and asks who's going to act as lead counsel. I understand that to be the representative who stands on their feet and addresses the court. I certainly don't consider myself to have the same professional qualifications as a barrister or silk or whatever the other terminology is in the English system.
Yeah, well, I understand it's being used generally just to mean advocate in sort of the arbitration parlance. Is that right?
I participate less frequently in the arbitration world than I do in the courts world, and so I mean that's something I'd probably go ask my arbitration colleagues, but I don't.
This is just a my curiosity rather than anything else. But if do none of the partners refer themselves to themselves as counsel in your firm?
Well,
you drew attention to the fact that you're a salaried person rather than an equity sharing partner, but that seems an odd distinction for the purpose of using the word counsel.
Well, of counsel is actually a professional title at my term as opposed to a relationship to the court. I don't believe our London office or any of our other non-US common law offices have barristers who refer to themselves as counsel. I've never heard any of the solicitors refer to themselves as counsel in that sense. But in any event, what we understood from Pinsent Masons, because they specifically differentiated counsel from HFW, being the solicitors. So that is what they understood. I don't have any more information on it than what they told us. And in any event, this is a point that was made in the first witness statement and was not responded to. So we reject the assertion that it's new. This is just information we were told. Now, there been a number of points made by Mr. Shivji about things we should have done to reduce costs in the litigation, and that it therefore does not lie on our mouth that we should ask that costs be reduced by the liquidator. But we would say it is one thing to say that the liquidation should be conducted with an eye towards the management of costs, including by not incurring unnecessary travel costs, which are very expensive right now, by the way. I go back and forth to London a fair amount. It is not cheap. Hotel rooms in the DIFC aren't cheap. 2 weeks trial in the DIFC is going to incur some pretty significant expenses. But it's really quite another to say that defendants should refrain from defending themselves in order to save the estate some costs. It's really quite offensive to justice, in my view, that he would make a suggestion that the defendants, as a matter of cost, should refrain from defending themselves in ways that they deem to be valid. Now, I understand that we've lost a number of applications, but we have also won some. And so the court should not accept the submission that the fourth defendant is not in a position to raise the issue of costs here. Mr. Shivji went through what the regulations say is required of a practitioner in order to be qualified to act. And again, we would differentiate what a qualification to act is from what is prudent in a particular case. Here, where the claimants already made a big deal in a witness statement about the location of things being in Dubai and therefore the litigation needing to be in Dubai, that same standard should apply to where the practitioner should practice in a circumstance where it was explained to us that there are a number of hard copy documents, and that should be a factor that the court previously weighed in favor of jurisdiction. Here we would say it is a factor that the court should weigh in favor of the location and expense reduction of the practitioner. Now, they also say that we endorsed this creditors meeting by participating in it. Again, we reject that. We made our objections to the procedure, I believe, clear during the hearing of the 18th and 19th of April. We stated how we thought that things should proceed. But we also, of course, didn't want to waive or lose any rights by not participating. And given that an office holder really does have the ability to call a creditors meeting in their discretion, we weren't going to resist the fact of the creditors meeting. And the court will note on our voting form that there was a provision voted for that discharged Mr. Hayter that our client abstained from. So This is a far cry from an endorsement of the process that they put in place. It is a mere participation in it in order to not lose rights. Mr. Shivji doesn't really grapple with the fact that the regulation 9.1, where he refers to 9.1 in its description of a simple majority, he doesn't grapple with the fact that in relation to the Chapter 6 regulation that he points to for setting forth the procedure, I believe at 6.13, that it does state clear majority, and that really must mean something other than simple majority. He says that this would be a departure from all other common law jurisdictions.
What does it mean? What does it mean?
Well, something well in excess of 50%. I think this is one of these legal terms of art where you kind of have to put a number on it. Even though the number may be imprecise, but is maybe something like the difference between preponderance of evidence and clear and convincing evidence, which, again, in American terms, lawyers sort of think of as the difference between a sort of greater than balance of probabilities, or something closer to like 67%. And we say that they recognize this difference, and even though they're not advocating for it here, that this is the reason that they adjudicated BJSS's proof of debt at a significant discount. Now, Mr. Shivji took the court to the transcript, and I would just say that the arguments that he put forward on page 818, they really sound an awful lot like a fetter on the court's power. It is unclear in what circumstances Mr. Shivji would say that the court has any supervisory role when there is one creditor who has a majority of voting rights. He says that he made a generalized statement that the court does have supervisory powers and that it can exercise them in certain circumstances, but it doesn't say what those circumstances are or why it would be inappropriate here. We hear that to mean that the court should never intervene in a circumstance where there is one creditor that has a majority of voting rights. We say that that would be dangerous precedent for this court to set, that it should not do so, and that the court, again, should, in its independence, appoint the new liquidator and discharge Mr. Hayter from office.
Okay. Thank you very much. I'll give you reasons in writing to follow, but in relation to the application that's been made, the application fails. In relation to the question that the court is asked to answer, was Georgina Eason validly appointed as replacement creditor at the creditors' meeting on 29th of April 2024? The answer is yes. And in relation to the question, did the liquidator properly adjudicate BJSS voting rights at the creditors' meeting on 29th of April 2024? The answer is yes. And in relation, therefore, to the remaining issues, who should be appointed as the new liquidator, or for any further order, there is no need for any further orders, but to the extent that it's necessary, the court approves and ratifies the status of Miss Eason as the current liquidator of BSA. So I think that leaves only the question of costs we have to deal with.
I'm grateful, my lord. On costs, we've got our cost schedule at page 1015, and the sums are expressed in dirhams. Our position is that in light of the highly unsatisfactory nature and timing of this application, we should have all of our costs. The estate should not have to bear any of the costs of dealing with this. This is simply an application that should never have been made and was pursued entirely for tactical reasons, as I've said, to disrupt the litigation and put the liquidator under personal pressure. And we say that in those circumstances, BJSS should not be entitled to a discount they should have to actually pay the costs incurred. And the total figure, my lord, is at 1016.
That's 275466 is what you're looking for, dirhams, is that right?
Yeah, yes, that's right, my lord.
It's about $75,000, is it?
It is about $75,000, and it is, I would repeat, double what we incurred.
I'm just looking at yours, that's Martin. Yes, all right. Apart from total quantum, are there any individual points you want to make, Miss Martin?
Three counsels seems excessive in our view, along with 3 solicitors. I mean, I anticipate that that's the reason that the costs were so inflated on our view.
Well, I'm looking at the individual elements of it. Do you direct your criticism to anything in particular? Well,
for instance, Nick Berganza charged out the same number of hours that I did, and he's not doing the advocacy. So it turns out that the advocacy really drove up the costs on their side. I don't know what the correct allocation should be as between solicitors and barristers, because of course we don't operate on that model, but it just seems to me that that's highly duplicative and unnecessarily expensive.
Yeah, anything else you want to say?
Again, it just really seems like double the work for frankly, I mean, we had the carriage of the bundle, we had 2 sets of evidence. It's really unclear to us why they incurred such extensive costs in this matter.
Mr. Shipperton?
So, my lord, this, as you can see, the bulk of the costs are actually down to counsel.
Yeah.
And this, I mean, there was plenty of work to be done on this. I mean, we've cited a number of authorities. We had to go back through, obviously, conduct quite detailed research to find the relevant authorities. I mean, it's a matter for my learned friends what they choose to put in their schedule of costs, but their schedule is very light. So just looking, for example, at my learned friend's time, she has put down a total of 5 hours for work done. So her charge is simply 5 hours of her time and the attendance today. And I mean, all credit to her that she prepared this application in that time. I took 3 times as long to do that. I mean, it was obviously a lot of work to go carefully through the evidence to make sure that our evidence in answer was appropriate, that we had dealt with the new points. I mean, even the new points overnight, my lord, for example, the public policy point about whether or not there's a requirement for office holders to be based in DIFC. I think that probably added 2.5 hours extra time after we'd researched the basis for the DIFC registrar of companies list of insolvency practitioners, analysed the list, etc., looked at the authorities. So it does take time. And I just highlight the point I made earlier, which is that Miss Eason was in personal jeopardy for all of this, because it was being said that she had essentially improperly assumed the office what she was not validly appointed for. And if that was right, of course, the personal consequences for her would be severe. So it's natural that we've done this, we've dealt with this seriously and appropriately, and that's how much these things cost. And I would also just point out that although my learned friend's cost schedule on this occasion was very low, on the last occasion, their costs were in excess of, they were $600,000 on the removal application.
Yes.
And the figure there is at page 1007 of the bundle. So we say compared to, it may be that they did a lot of work then and they were able to utilize that on this occasion, and that good for them. But we needed to do the extra work, and I'd say $75,000 for a hearing of this significance is not significant. And then finally, poor old junior counsel the junior counsel always gets it in the neck. But if Mr. Sharafi, who is our junior, his fees were £2,000. So really, I don't feel that he is the person to have broken the budget. So we say that this is appropriately staffed. And then although my learned friend's skeleton argument only has 3 attendances today, they've got how many attending?
3 extra.
3 extra. So they have not. They've got 3 members of their team who are not on their cost schedule but are present today at today's hearing. So that obviously their schedule can't actually cover the full extent of their costs incurred.
Well, no doubt they're learning. 200.
My apologies. Could I just point out that we do have another senior lawyer on the matter, Mr. Devonish, who is able to relieve some of the burden from me. So it's one of the reasons. And I also just happen to have an excellent mid-level and junior team who was able to put this together for what I think was in the appropriate amount of time. Yes, we did spend significant amounts on removal, and we believe it was merited there, and we believe that this could be done efficiently, and that $35,000 is approximately the right amount to be incurred here.
Yeah, all right. Well, it's a summary assessment, and the figure I come to, just looking at the totals and not criticising any particular element of the bill, is 230,000 dirhams. All right. I will let you have my reasons. I think it'd be pretty obvious from the conduct of the debate what they're likely to be, but you should get them. Well, the court will get them later today. When you'll get them is another question. As to the form of the order, rather than have any debate about that later, in almost every case so far, when I've said to the parties, I'm sure you'll be able to agree the order, it's then come back to me with a dispute. So would you like to formulate the order now, Mr. Shivji, by which I don't mean the recitals, I mean the actual form of the order, and dictate it so that we can see whether there's any room for dispute?
We will do. I'll do that. We'll do that right now, my lord. But I'm going to ask my junior just to help me with that as well, to make sure we've covered everything. But can I just address you on one other point while he's doing that?
Yeah.
Sorry, if you just give me one moment, my lord. Sorry.
Yeah.
Can I just ask it? Sorry, it's a separate point, but in terms of your lordship's case management directions for the hearing on the 10th of June, we are due to file a number of documents on Monday, and we would like 3 extra days to do that. Can I just show you the order, which is at page 392 of the bundle?
Yes.
So it's paragraphs, it's just 6 and 7 that I'm addressing you on. We have to give our electronic disclosure questionnaires and information about hard copy documents on Monday, and also our case management information sheets. And
Yes.
I mean, this application has been very distracting, and we need a little bit longer. We need until Thursday, the 30th. Now that's still a week and a half ahead of the CMC, and ordinarily under the English rules, these documents would be filed 7 days before, CMIS would be filed 7 days before the hearing. So we think that there's still enough time, and I do apologise for it, but just looking at what the importance of these documents and what we still have left to do, we don't think we're going to be ready by Monday, but we think we would be ready by Thursday. So I would ask for a short extension just in paragraph 6 and 7, please.
Ms. Martin?
Well, this is the first time I am hearing this request for extension. It would have been appreciated if it had been raised with us previously. But that said, it's acceptable as long as both parties get this time, of course.
Yeah,
Yes, of course.
Of course. And I'm very grateful to my learned friend for that. And I should say that we have separately written to them with a whole load of preliminary disclosure points that we really need them to engage with. I worry that may not happen. But I'm just laying down a marker now, because if we don't get proper engagement from the defendants about disclosure, then the time spent at the hearing on the 10th of June will really be on preliminary matters rather than the nuts and bolts of it. But that's just a marker I'm laying down for that forthcoming hearing.
I would like to, my apologies, but we received that letter 2 days ago. It asks for quite extensive information. Not all of it is clear to us that even could be provided subject to the Swiss law requirements. So, and it asks for a 2-day turnaround. And it is typical in our experience that the claimants initiate discussions on the points that the parties need to discuss. We would have appreciated if they would have engaged in these discussions much earlier. But we will endeavor to do our best when it comes to responding to their letter. But what I don't want is for us to say we're unable to turn this around in 2 days, and for Mr. Shivji to come back and be like, oh, look, they're uncooperative, like they're always uncooperative. That is just simply not the case. They just got us the letter very, very late.
Well, sorry, Manon. Sorry.
What I'd like to know is at present what is envisaged to be the likely content of the case management conference on the 10th of June. What are the areas for debate that are going to come up?
So, my lord, maybe if I could just take you to the letter, because that starts really sort of setting out hopefully some of the agenda items. And the letter appears at page 1003 of the bundle. Can I just, we don't need to go back and forth on this, but in terms of my learned friend's complaint about timing, the current application that we're hearing today obviously caused us significant difficulties, because we had to think very hard about whether we were confident that Miss Eason had been properly appointed and whether it was appropriate for us to continue to act while the issues of her appointment remained outstanding, because of course all of the team would be in jeopardy if they didn't have the authority of the company. So and we say that was the design of my learned friend's application, and it did have that effect. So if they complain about the timing of this letter, it is entirely driven by the removal application and the fight on that, and that's the reason why we're behind schedule. But in any event, these are points that they ought to have well on their agenda. Is your lordship just having a look at the letter? Shall I wait a moment? Sorry.
Yes, I'm just looking, but this is likely to be the ambit of some debate at the case management conference, is it?
So
depending, of course, on what the answers are. But
yes, so I'm hoping. I mean, some of the points hopefully we can clear away. So this point about making obviously sure that the individual defendants are not the decision makers on the fourth and fifth defendants disclosure process. I mean, that's a no-brainer. They can't argue with that, but they will need to give that confirmation, and they will need to make sure that the individual defendants are not giving instructions to Jones Day in relation to the litigation for the fourth and fifth defendants. There's a point about the group. I think that ought to be uncontroversial as well. And then it's the usual sort of points about understanding actually what they've got, where they've got it. Yeah. I envisage that we will need to flesh out some of these Swiss concerns that they have.
Well, I can see that could be an issue.
And our view at the moment, my lord, is that that's a good item to put on the agenda for that hearing. And in particular, it's going back a while, but your lordship may remember that Mr. Carton's employment contract from BJSS was redacted, and the redactions we think are quite extensive. We were told that the redactions related to just his remuneration. It was never very satisfactorily explained why the redactions were made, but we think that is the sort of issue that could come before your lordship for determination on the 10th of June, because although there are a range of possible Swiss law points that have been raised, we think actually most of them don't bear scrutiny. We don't think it's open for the fourth defendant or Mr. Carton to redact his own contract on some data protection ground or banking secrecy ground. I mean, both parties, this litigation, they've got to give these documents unredacted, and they are material because we think that Mr. Carton was financially incentivized to act in BJSS's best interests, not in BSAM's best interests. So that is the sort of thing that I think we'll have on the agenda. But to be honest, my lord, it does depend on the level of engagement we get from the defendants. If it's a war of attrition, then actually we may simply be asking for more information at that hearing, and then we'll have to come back later for a more granular hearing. There's also, my lord, the point about the sort of detailed mechanics of the searches, and on those, I mean, your lordship will have, some of those hearings can be quite painful, admittedly, but your lordship will know that the best way is actually for a high level of cooperation between the solicitors, with a view to agreeing appropriate search terms by reference to what's sensible and appropriate for the case. And the court really ought not to be bothered with those unless there can't be an agreement and there are points of principle that need to be ruled on. Our sense at the moment is that although we would like to have that discussion well underway by the hearing on the 10th of June, it's probably unlikely that the court will be asked to make rulings on that on those issues at that point. And it may well be that the parties just need to go away on those points, continue discussions, and then if there isn't an agreement, we come back before you later. And also, subject to your lordship's diary, after the hearing on the 10th of June, it might be worth putting another case management conference in the diary a little bit down the line, because my experience of these things is that the time is often usefully spent. And it also focuses everyone's mind that we've got to come back before your lordship and explain what we've been doing or not been doing. So I'll ask for that on the 10th of June, but not before.
Yeah, and how much later would you envisage that further CMC to be?
I think it would probably depend in substantial on your lordship's diary. So we're quite flexible on that front. But my experience is that you need at least a couple of months between CMCs, because it takes you take a month to essentially prepare for a CMC, and you need to have actually made some progress between them. So
if we're dealing with disclosure issues, we've got 3 weeks now, have we, till the 10th of June?
That's right.
To grapple with the question of search terms, custodians, all the rest of it, and as you say, that requires the parties to be in sensible conversation, with discussion backwards and forwards, with a view to getting as much agreement as possible. But if I have to decide on, the minutiae of such matters, and there's a lot of disclosure still to be given, then certainly the next CMC is going to be another 2 months down the line, which will take us probably into August or something, which is not very attractive from English Council's point of view. I'm not quite sure how it works for holidays for those who are in the DIFC. They nearly always leave Dubai if at all possible in August, as far as I can gather.
May I just bring up a couple of additional points that I think will be important?
Yes.
I understand the claimant's desire for integrity of the process, and we are here as legal counsel to stand as a bulwark for that. And so without taking away from that, if counsel wants Mr. Astruc and Mr. Sassoon to be entirely excluded from the process, we lose the bulk of, if not the entirety of the institutional knowledge when it comes to the location of documents. So I would suggest that excluding them entirely would be a bad course of action. Now, we, of course, are going to undertake this exercise with the appropriately independent people and e-discovery professionals, and in the way that one would normally expect a law firm to do so. But I think they put forward a very dangerous proposition in terms of location of relevant documents and information. I also, in our discussions with Swiss counsel, what I would suggest is that Mr. Shivji seems to have a very optimistic view of what might come out of and maybe it's not just Mr. Shivji, maybe it's the claimants in general, but they seem to have an optimistic view of what might come out of the letters rogatory process to Switzerland. My understanding is even if provided through a letter rogatory, if the Swiss courts receive a letter that basically says that we want discovery coextensive with English rules or even the IBA rules, which effective in the DIFC courts, that they'll just reject it out of hand. And so the suggestion that we intend to put forward to Mr. Shivji's clients is that the Swiss lawyers engage with each other and come up with a protocol that the parties agree on. And it is our intention to seek agreement, but we think that all the parties should be very realistic about what is likely to come out of that process. Again, reminding him, this is not just data protection. This is not just Swiss bank secrecy. This is the Swiss criminal code that applies, and which there would be an abrogation of if they try to circumvent that process.
Well, I understand all of that, and certainly Swiss lawyers need to be engaged to look at the realities of the situation. The problem which always arises in such a case, Ms. Martin, is that, as you well know, often where there's an absence of disclosure, then inferences are drawn against the party that fails to make the disclosure. That becomes particularly difficult and sensitive where there are bans on disclosure in consequence of Swiss banking legislation or whatever it may be, which is very difficult indeed. So these areas of dispute have got to be hammered out and discussed, and enough information given to the court so that it can make rulings on it, which may very well involve, I suspect, issues of Swiss law and so on and so forth, and heaven help us, but evidence from Swiss lawyers in witness statements as to what the law does and does not allow. I mean, if this is what's going to happen, then the hearing must be properly prepared for, and the material must be before the court so I can make a decision.
As well
We've got 3 weeks at present, but I think it's almost inevitable that there'll have to be a further hearing, and the only question will be when. How long have we set aside for this hearing on the 10th of June?
We sat down a day, my lord, and I don't, just on your lordship's point about the risk of prosecution. I mean, there's a few points. I mean, actually, the way that this normally works, as I understand it with Swiss institutions, is that they run a standard disclosure exercise so that they can identify the list of documents that are responsive. And then the application that's made to the Swiss courts under the Hague Convention identifies the material that's already been found as part of the search. So it isn't some roving order where the Swiss court just simply makes a non-specific generalized order. The exercise is done, and then they just get validation through the Swiss courts to produce the documents. So we don't see that as a barrier.
Well, I understand that. What I'm saying, though, Mr. Shivji, is that if that's the position, I'm going to need to see evidence from Swiss lawyers as to how all this works.
Yes.
I would remind the claimants that the Hague Convention is not applicable here.
Well, let's not argue that here and now. That's exactly the points that need to be sorted out with appropriate submissions and evidence at the CMC. But you need to be debating all this to isolate what the issues really are, and what therefore does need to be decided. And the sooner people get on with that, the better. I say 3 weeks ought to be enough to sort out at least the very basics of the exercises that have to be done.
Yes. Yeah, and the point that your lordship made about the risk of prosecution, that's the Bank Mellet Authority, and they will need to show that there's a very real risk of prosecution. And things like Mr. Carton's employment contract, we just see it's unthinkable that they couldn't produce his contract without redactions because there would be a risk of someone prosecuting them for it. Seems unreal. But anyway, we'll need to figure that out. Your lordship's also right. I mean, this affects the documents in Switzerland, but of course, the fifth defendant will have its documents within the jurisdiction. So it may well be, I mean, often the route through on this is actually, a lot of these institutions have servers backed up around the world in different locations. And the answer often is, well, you just take the documents out of a jurisdiction that is outside Switzerland. So we'll have to have a discussion with with them.
Yes.
But my experience is that there are many practical ways through. And so for our part, we're not going to accept the idea that it simply can't be done. But we'll have to discuss it. And if we can't reach agreement, we'll be back before you.
Yes. All right. Well, I mean, if there are scheduling problems in the diary, if necessary, we can have, two early morning hearings of shorter duration or whatever it may be.
I'm grateful for that. And sorry,
but one's diary changes the whole time, as you know, so that sometimes things can be dealt with at short notice that on the face of it looked as though they were impossible even a day or two before.
I'm grateful for that, my lord. And sorry, just dealing with my learned friend's point about the involvement of Mr. Sassoon and Mr. Astracht. They're obviously a source of information.
Yeah,
there's no problem that you can rely on their the information that they can give. But the point is that they are very senior executives within the fourth defendant, and they must not be running this litigation for their own personal advantage. It must be run by an independent senior executive of at least their seniority or above them, who can ensure that the whole process has integrity from the fourth defendant's perspective, so that you don't have senior officials deciding how the fourth defendant conducts the case to avoid scrutiny of their own actions. And of course, it would be an entire breach of duty and a conflict of interest for them to do that. So we would have thought that Jones Day would be putting those measures in place for their own protection, as well as for the protection of their client.
Well, you put down a marker on that, and Miss Martin no doubt has taken note. And if there have to be witness statements about who's controlling the process and who's giving instructions, and how Jones Day in cooperation with their clients are supervising disclosure, so be it. I appreciate in this case there's very little trust between the parties, and therefore we may need to examine all sorts of things that ordinarily would not require examination. There we are.
My lord, I'd said I'll come back to you on the terms of the order.
Yes, that was the next
I'm grateful to my learned friend, Mr. Sampson, who's been busy typing away. So the two parts to this. The first part is the declarations that your lordship gave, and paragraph 1 is it is declared that paragraph 1, Miss Georgina Eason was validly appointed as liquidator of BSA at the creditors meeting held on the 29th of April 2024.
Yeah.
2, the chairman of the creditors meeting held on the 29th of April properly adjudicated on BGSS's proof of debt for the purposes of voting at that meeting.
Yeah, but it properly adjudicated for the purpose of voting is probably good. It's the question of it's a provisional adjudication. That's the point that somehow needs to be included in there, so it's not a decision once and for all. And although people who understand the process may realise that, I think the order needs to incorporate something of that kind.
I think we could just insert some words in brackets to say without prejudice to any subsequent adjudication on BGSS's proof of debt.
Exactly. But you happy with that, Miss Martin?
As long as it's also without prejudice to any objection there too.
No, I'm not sure I understand that.
Well, without prejudice to any subsequent adjudication, meaning that a subsequent liquidator can separately adjudicate them, but that we could also object to whatever those adjudication results are as well.
But that flow, I mean, your right to object any flows once there's been an adjudication. So,
and that can't be travelled with in any event. You can't be stopped from objecting and saying you've got it wrong.
Yeah, agreed.
That is clear to both the court and opposing counsel. I'm happy with.
Yeah. So, well, I just so that my learned friend's clear, that I think his lordship's point is that we've adjudicated on the proof for the purposes of voting. Yeah. But we have not adjudicated on the proof for the purposes of determining the validity of the debt owed by the company.
Not the proof of debt, exactly. Yeah.
No. And when that is that latter point, the adjudication on the proof for the purposes of the claim against BSAME is adjudicated upon. If the fourth defendant is unhappy with that adjudication, they have a statutory right to compel.
Yeah, absolutely.
Well, it's on the transcript, so that's all clear. And then, my lord, so those are the two declarations, and then we go on to say, and it is ordered that the fourth defendant's application is dismissed.
Yeah.
That's paragraph 3, and then paragraph 4. The deadline for so this is just the directions. The deadline for the sorry, 1 second, my lord. Apologies. The deadline in paragraphs 6 and 7 of the court's order of the 30th of April is extended to the 30th of 4 p.m. on the 30th of May 2024.
By consent.
By consent. And then 5th paragraph, the 4th defendant shall pay the costs of the liquidator, Miss Georgina Eason, summarily assessed in the sum of AED 230,000.
Yeah, how long do you want to pay that, Ms. Martin?
I understand that there are a number of people out of the office this week, so could we have 2 weeks? We'll try and get it out earlier.
14 days, yeah.
Thank you.
The only other thing I wondered about, Mr. Shivji, which I actually said in the course of my summary of what I was deciding, but I question whether you think it's necessary or helpful.
That's right.
Was to the extent necessary, I'd ratified and approved the status of Miss Eason as liquidator. And what I was going to do in my reasons was to say that I didn't think that she was in any way unsuitable, and had this court had to make a choice between the two candidates involved, without saying that either of them was in any way unsuitable or doubting their integrity or anything else, the court would have chosen Miss Eason because of the principles set out in the Ferrier case, Fielding case.
I'm grateful, my lord. Actually, I'm grateful to your lordship for raising that point. Actually, on reflection, we ought to have that in the order if your lordship's happy. So we could insert that after paragraph 1, just to say that insofar as, or if contrary to paragraph 1, Miss Georgina Eason has not been validly appointed as liquidator, the court would in any event ratify.
Well, I think I'd rather have it simply to the extent necessary. The court approves and ratifies the appointment of Miss Eason as liquidator.
I'd be happy with that. Thank you, my lord.
Any comments on the form of words, Miss Martin?
I think, as the court indicated, I don't think it's necessary for the order, but with the reasons, I would appreciate if the court would rehabilitate Mr. Stubing's integrity, because I think it.
Oh, yeah, no, don't worry. It'll be quite plain. There's no suggestion that he's in any way inappropriate, and indeed, I've he's been involved in other liquidations that I've had to have dealings with in the past in the DIFC. So no suggestion that he's inappropriate in any way at all.
And sorry, just to make it clear that I wasn't. There has been no attack on my part on Mr. Stubing's integrity. No. I mean, he's, as you say, well recognised by this court. Has been appointed before. Has an impressive CV and comes from an impressive firm. So there was no suggestion on our part of any criticism of him.
All right. So that's it until the 10th of June, unless someone has disputes between now and then. Yes, so. Very good. All right. Well,
thank you, my lord, for making time. We're really sorry that you've had to. I'm sure your diary is very full, so I'm very grateful that you took time to schedule this. And for our part, it has really helped us, because it is not satisfactory as an office holder to have the sort of Damocles hanging over you, and it's good to have that cleared away. So thank you.
As it happens, in the arbitration I'm in, we gave them the day off today to write closing speeches. So had I known that in advance, we might have begun at a slightly more civilized time, but there it is, that's life. All right, thank you both very much indeed, and try and agree as much as you can before the 10th of June.
Thank you, Your Honor.
Thank you very much. If you'd like to sign out, I'll talk to the associate, please.